thing to make the sound go. Please try and listen to the lecture.
Hello, and welcome to the next to last lecture of the semester. This is a particularly important and completely not an ethics subject, but I think it is fundamentally important to your understanding of what engineering ethics classes are and to how your professional practice across most fields will go. So here's the simplest answer. If ethics is primarily a question of what is the right decision, how should one act, it doesn't actually, in most cases, treat past actions in evaluation in the same way. But in ethics, the evaluation of past actions are always still based on systems of evaluation. And because those systems of evaluation, whether they are utilitarian or fundamental basis, which turns into a deontological premise or a complex one, the answer is still always to tell us what is ethical, what is desirable, what is right and wrong in terms of action. It doesn't tell us necessarily what we'll do with that. According to ethics, those evaluations then give us substance to produce a new action. We can decide what to do next. And one of the fundamental difficulties of that is that we often want to think about things like punishment or paying back or recompense as being part of the ethical system, but the request for the demand to do some sort of repair is actually a separate ethical decision than the action in the preceding case. The should one pay for it? Should one produce a problem? That is, should one pay for it or try and fix it if you have made a problem, right? That's just a new question. You apply ethics, you decide what to do next. And we don't talk in ethics about that as liability. So this is the lecture where you'll hear, instead of about ethics, what your bosses are likely going to say. And the concept of liability is literally whether somebody can be held responsible, not based on a ethical theory, but under a legal theory. And in most cases, tons and tons of things in our world are the way they are to try and prevent or respond to past cases of liability. And those range from things as strange to you as those tags that say don't take them off on pillows, the safety warnings on doorways or on the wall in the airplane, the fact that everybody has to listen to the airline's safety speech every time, the fact that you're taught the way you are, including this engineering ethics class. One of the reasons we design institutions and systems, technologies, and products the way we do is to be able to control and respond to the system of legal responsibility. And so understanding the very basics, which you guys saw in that ASQ article, that's an article that's actually designed to be given to engineering students so they get the basics. I don't think it goes far enough. And we are talking about that this week, understanding that it is not ethics, but a parallel sort of system that you have to be aware of. So, as I said in the last slide, ethics is different from liability. And we're going to talk for a minute before we get into the content of the lecture on ethics and the content of the lecture on what the articles talked about, because there are some interesting points that are worth considering, both because you have to live within the world that liability interacts in, and also because you, as technical and educated professionals moving out of your college degree, you're going to be part of negotiating these things in the future, both as voters and as members of society, and especially as technical participants, business owners, engineers, programmers, etc. So we're going to try and get these things clear. And as I said, the SQ article by Dick Mall lays out the very basics. we'll come back and talk about the core issues in both of our Dar and Wagner piece about how long we can imagine liability lasting, and also the Michael Willits piece, which suggests it may be important for us to take liability more seriously and to actually say that having sheltered liability in civil court and making it very difficult for us to take really, really harsh penalties may not actually be the best way to produce an outcome we want. So to connect to a variety of other things from this semester, we can think of liability as a system by which the politics of objects are negotiated. And this goes very specifically back to how Langdon Winner talks about politics. The basic premise of liability is to establish responsibility so that we know if a winner or loser is supported by the system of liability. For instance, if I walk down the street and I slip and fall on somebody's property, they have legal liability because it is their property. But if I am slipping and falling and I should have been more careful, if somebody could show that I was skateboarding or if I was doing some activity where I am more responsible than they are, then the system of liability would say that I'm just the loser. They don't have to share in that loss. And so the system of liability is largely about what we're going to expand that idea of politics to think of as the proportional responsibility, right? So all sorts of stuff from this semester, social construction, politics from Langdon Winner, the system by which our designs are done, all take into account who is contributing and controlling. Because among other things, our consideration of agency and power means that if I set up a situation and you have to suffer the consequences, but you don't contribute to making that situation, it is more about what I did than what you did by accepting the situation. That's proportionately more my responsibility. And as silly as it sounds, the best simple example of proportional responsibility, imagine you and several friends, brothers, whoever, you're sitting down to a table and you have a cake to cut up. And you sit down and you have the knife and you have the cake and everybody is eager to eat their cake, and you slice one half of the cake and shove the entire half onto your plate and you keep it. Everybody else is stuck sharing the other half of the cake. You are responsible wholly for the division of assets. And in fact, you could choose to just refuse to share the cake with them. You could just hand them empty plates and say that you're keeping it all for yourself. Or everybody could cut once, dividing up the cutting and then randomly assign the slices so that everybody shared equally in the responsibility for the division of the cake. In most cases, what we're going to actually see is something like the old childhood rule of one person cuts and the other one picks. And that sort of situation in which if there is a disproportionate responsibility, you respond to it by allowing a fix. So if I am given the opportunity to cut the cake, but then other people choose, I will likely get left with the smallest slice that I've cut, unless, of course, everybody else doesn't want a larger slice. But it prevents them from being harmed by giving them too little cake. And so what we're really trying to get at is the idea that it's not just the amount of the cake that is the question. It is how the cake is apportioned. And so in considering that, we're really talking about not just the ethics of how you do it, right? We're talking about a combined system that looks at how the end result can be responded to. And so in the legal system, the ultimate responsibility in which your system of determination places responsibility, the ultimate responsibility, is determined after the fact. And in many cases, that means that you may see something as being entirely not your fault, not your responsibility, but the law may place responsibility on you. And so what we're going to be able to see is that issues and concerns like transparency and honesty, like the system by which information is provided or standardization is set, can affect these things. So we'll come back in a little while to talking about what liability is, but I wanted to remind you of a couple of concepts. First off, we've talked before about risk, both starting to talk about it when we did the first case study around the Pinto case. We'd actually mentioned risk and safety before that, but we really started to begin about it, about how you balance those two different things. And risk is whether or not a kind of outcome is inappropriate or unacceptable, right? So, for instance, if you wanted to do something and you knew that it was harmful, it's not a risk anymore. It's just a known harm. But if you are unsure if the outcome is appropriate, if you are find the outcome unacceptable, then the risk, the ratio or probability of that outcome becomes known. And one of the challenges about risk is that there is a significant difference between knowing risk versus an unknown and knowable risk. Um, for instance, do we hold somebody responsible if they know something? Yes. Well, what if they know something could be learned? They could look up whether there's a risk. They could learn more about it. Um, and in fact, as we get into the discussion of liability, it may be worth keeping this in mind that for the sake of liability, in many cases, a known risk and a knowable risk are effectively the same thing. If you could go look up what the risks are, that is the same from a sort of legal liability standpoint as knowing that something is risky. Therefore, the assumption often is that if you could have known, if you should have known that it was a risk, and you said it is an appropriate and acceptable thing, then you are responsible for that. And so risk and the way that you construct the appropriateness and acceptability of outcomes becomes central to what risk is. And those are very different cases when you could know something than if something is just completely unknown. And a classic example of this is the negotiation of something like, you may or may not know that asbestos, which is a naturally occurring mineral, was made into insulation sheets because they were fireproof. And for most of the 20th century, it was actually a product that came into use in the 1880s and was widely used from the 19 teens until the 1950s. And the science came out that being exposed both to damaged and manufacturing of asbestos tile and sheeting, but even just living in a house with it had potential to cause a significant harm. Now, when we talk about risk, one of the things that we think about again is having your walls harm you appropriate and acceptable? No, right? You don't want your walls to harm you. So if the roof is harming you, if your walls are harming you, if your basement is harming you, then we can look at accepted ideas of what risk is, of what kind of outcomes are appropriate, and we can know that that is now a risk. But the science wasn't there until the late 50s or early 60s to know. So in the United States, we say that was an unknown risk up until the 50s and 60s. After the 50s and 60s, some companies continued to use asbestos. And in some cases, that was because they just didn't know, but they could have known. And in other cases, they chose despite knowledge of the risk. And their argument is that the benefit outweighed the utility, the risk, that the utility was necessary. And so when we come back later, we'll talk about that as a possibility. There are times where a known risk, even when we accept that it's a risk, may be necessary or advisable. And this is in contrast to the idea of safety. In safety, we're talking about the definition is that risks are limited and comprehensible, right? You're either accepting risks as being minimal or appropriate, right? They're the acceptable risks, or there are no risks. And the appropriateness of outcomes of the types and probabilities of the outcomes in any specific context produce that risk. It is context specific. And so, like safety in general, our question of liability becomes different in context, going all the way back to our discussion of context as appropriate to the understanding of politics of artifacts in Winter. Anytime you're talking about safety, we will be able to see disagreements about context-specific things. And on the slide, I use this silly example. A soldier in a war zone considers life not just safe to have a weapon around, but it is safer because of a weapon. Whereas a school teacher having one in a school full of small children, even if they felt safer, we might have disagreements about whether or not the actual acceptability of the risks involved were appropriate. And one of the key elements that we talked all too briefly about when we talked about newsmen another week was the idea that problem and solution agreements matter, right? So one of the things that happens with negotiations of risk and safety is some people will agree that the problem is this and the solution matches that. Other people disagree, right? Technologies are very rarely absolutely perfect. If it's possible to be absolutely perfect, that's usually a product of matching its context as opposed to being perfect in every context. So if you imagine a technology that you can think of as being excellent, no one could disagree according to you. Take it to a completely different context. If you thought of a fancy technology, imagine somebody who doesn't have enough money to buy it. Do they think it's perfect or should it be cheaper? If you're imagining something that tastes good, do you think that everybody will automatically think it tastes good? The nature of what the issues are that define a problem are variable. And so, in fact, if you went to law school, and any of you could potentially go to law school, one of the first things you learn and spend time working on is what's called issue finding, right? You determine what is important in this context, in the way something is, how we're going to talk about it, what we need to pay attention to. And in law, the list of those issues that are important are partially constructed by the law. So, for instance, if you're talking about a specific subject, there are legal cases in the past that say in cases like that, you have to be able to answer this question. Doesn't matter if you can answer 500 other questions if you cannot answer the question that past legal cases say. The question of how a technology responds to the complexities of a situation means that you may think you're answering the most important problem and somebody else disagrees. And the entire nature of liability takes that into account, not because it thinks that it will solve it, but by simplifying some related definitions. The idea of liability says those conflicts of problem and solution agreement, those conflicts of definition of risk and safety, of who gets to benefit, those problems of system complexity, those problems of politics of artifacts. We will solve that by saying that as a social rule, certain things are acceptable. And so as we move into talking about the law, what we're really going to try and do is get to the idea that there is a social premise, a group idea that is supported by the fact that we have to live in a group. And at its core, the law should be doing that work. So in the last slide, I was saying that if we move into talking about the law, we need to understand that the law is about producing a balance so that we as people living together in a group, in a society, have it perform a function. And that function of law is to perform an ordering society, an ordered society, to perform a prevention of overt conflicts. And in a democratic society like the United States or most nations, It allows both a permission of popular control, that is, everybody has some impact on how decision making and structuring of society runs, while also limiting it. So, for instance, no one person, not even the president, can just go, haha, now eating strawberries is illegal, right? There's no system by which one person has absolute power. And at the same time, the system of law allows other people to contribute and respond to group decisions. The law serves a structuring function between the different ethics, morals, differences of belief, differences of perspective, context, situation, biology, familial relation, culture. All those differences can exist because there is a system of law to sort of oil and balance the machinery's interaction. And in anthropology, there's a whole group of scholars who talk about this as a social system by which friction and flows are managed. And in any situation, we want the law to allow people to live with, ideally in this day and age, we believe in what's called individualism. Um, but that individualism, which says everybody should be able to do what they want, has to be limited by a shared system that prevents harms and negative effects for others and for the society as a whole. So law is the mechanism by which the pluralism can function. And in this case, pluralism is literally not just saying people are different. Pluralism is the observation and belief that there is something beneficial, not just to individual people, but to the society as a whole by having a diverse population. And that diversity extends to all elements, right? We want people who have different beliefs, people who come from different places, who eat different things, and huge variations in the population actually produce huge benefits for society, as long as they don't produce intense conflicts. And so laws attempt to balance all that stuff in complex ways. In particular, the social welfare, right? In fact, society might work better if there were less variations, but the balance for everybody is better when these things are in balance between diversity and pluralism on one side and social coherence and consistency on the other. Social welfare, that is what is good for everybody and anybody in the society, versus individual welfare, that is what is good for one person. Social benefit and public safety versus individual freedoms is an intense conflict in the history of political thought and political science. And anytime you're talking about law, you're talking about both successes and failures in balancing this. The law is a mechanism warranted, that is, the system that allows its right to exist by the simple structure of the society. That is, the society has a basis. Otherwise, we're all just random people who aren't connected. In the United States, historically, we've talked about this as the Constitution, but it's actually much more complicated than that. While the Constitution is the warrant for law in the society, the Constitution actually gains its warrant from the fact that we are a nation of people. And it's a weird thing that we can talk about another time or in discussion, because it's a derivative of the social contract theory that we talked about, right? Everybody has agreed to the Constitution in order to have the Constitution work. But the Constitution itself gets its power from the fact that everybody has to agree to it. So the law as a mechanism attempts to A, benefit all of society, and this is both a contemporary ethic and an aspirational one, right? The law should prescribes. The law should produce better outcomes for all people today while also maintaining and allowing for good futures. B, it is a deterrence and a reinforcement of desirable actions. Those desirable actions should have been the result of popular participation in determining what kinds of things are appropriate. Excuse me. Thus, we, by deterrence, by reinforcement, we apply what could be considered social ethics, but they're not the same as ethics. They're not things that are derived in the same way. So the goal would be to prevent bad actions, to prevent criminal acts, to allow innovation, to do these things, but never to be entirely in the same way as directive as an ethic is. These are meant to be shaping at the larger aggregate level. C, if something bad happens, it has to have a system to respond to past bad actions, to remedy or to provide restitution. And in the United States, one of the main ways that the law allows that to happen, past actions to not be punished, that sort of separate, but to fix bad actions or to make recompense. One of the ways that that's handled is by liability. Another thing that the law has to do is maintain the law. It cannot be so inconsistent that the law ceases to be warranted. So, for instance, one of the classic examples in the history of Western Europe was that there was a point at which, with the church's influence, the Catholic Church had produced a whole set of laws that applied to lots of people. So, for instance, bad actions could be punished by death, but if you were a member of the clergy, you would just get a slap on the wrist. And one of the reasons why we invented the modern conception of law was that the idea of a universal application of law, which derives some of its warrant from the same sources as the social contract, as the concept of human rights, meant that we did not have these conflicts based on there being different law for different people. And it turns out it's very difficult to have a law that seems legitimate if it applies differently to different people. And that shouldn't be taken as, well, if different people pay a different tax rate. That's actually the same law applying to different people. What we mean is that, like, for instance, the law says everybody is innocent until proven guilty in the United States, but it's pretty clear that, for instance, the application of that law is uneven and inequitable. So that, for instance, wealthier people do get the assumption of innocence. Working class and people of color tend not to get the assumption of innocence. They get sent straight to prison, at least for a while, because they can't afford to pay bail. If you can pay bail, the law treats you one way. If you can't pay bail, you're basically in prison as if you're guilty. And so the maintenance of the law is then a subject of specific concern to the law. It has to maintain itself as a legitimate thing. It doesn't always do this well, but the legitimacy is one of its concerns. And the response in the last thing we'll keep in mind is that the response and reply to popular conceptions and expectations. So, for instance, the way that we consider any given law will change because, again, the system of law is, in a democracy, responsive to who the people are, to what they think, to what they demand. The system is built to encourage and allow for their participation. None of this is as nice and clean as simple as formal ethics are. And one of the things is that we can still respect and expect the law to be, but most of the time we're not going to see it as something which is directive at a personal level, right? So when we talked a while ago about structural ethics, I said you don't have to agree with the law, you just have to have a structural ethic that says other ethical considerations, other processes of decision making are easier if you accept the law. And the reality is that there is a lot of space for ethicists and lawyers to improve these things. But at a basic level, it is advisable from an ethical standpoint to follow the law because the outcomes are better at both a deontological and at a most ways of evaluating consequentialist ethics. All right, so we've talked a little about what the legal system isn't and how complex it is, but what is it? So the legal system is a historically developed system by which complex rules have been established, and rules for the interpretation of those rules have been established. And that system of rules in which all the elements interact is as complicated as any technical system you can imagine. And in some ways, it would be easier if we were talking about a really designed system, but it isn't. It's in a system that is much more like natural systems. If you remember the accumulation of sediment layers introduced under pressure, and over time they turn into rock, or potentially evolution, although it's often difficult to talk about evolution as a metaphor without getting off on a sidetrack. But it just isn't a process of design. And in fact, most of the time, if I look at a classroom full of people, I can honestly tell you any one of you college students could design a better system of law than we have. That's because you would design a self-consistent system. Laws aren't self-consistent. Laws are rules, newer rules, new interpretations of rules, rules about how to interpret old rules, and then more rules on top of that. Rules that change how they're applied, rules changing what contexts look like or how to interpret contexts or what can be mentioned. And those rules pile up into such a degree that the rules had to be divided. And the division of laws is partially a very logical response to their complexity, but it's also a way of trying to prevent the inconsistencies in law from applying to each other. So for instance, the system by which we assign responsibility for actions can be different in two different parts of law, but if law was one consistent thing, it would potentially undermine the idea of law, that it was two different things at the same time. And the law is a system that has an ongoing and social, political, uh, linguistic, and various other ways that it's reinterpreted and forced into revision and change. And one of the classic examples of this that I use is 150 years ago in the United States, it was very unusual for women to wear pants, except when they were working in a field or doing something. It was considered somewhat inappropriate, in part because social rules of dress that we received from Victorian England um, made dressing like a man a problem for women. And it's easy to mark that down as history, except for the fact that 17 states, including some perfectly reasonable states, and many cities like Manhattan, still technically have laws on the book making it illegal for women to wear pants. You're not allowed to, not in public. And one of the things about that is that it's absolutely ridiculous to imagine that they would punish people for that. So at some point, Manhattan actually passed a law that changes what the punishments would be. And later on, they changed punishments and modified the law in other ways, including by court decisions that say you can't do that. But how those laws and how those systems work change all the time. And so, for instance, if you had a bunch of very cranky people come into a political position at the district attorney's office, there is no barrier to them attempting to apply the law against women in pants. The system of law is always a complex interaction of what's called statute, that is, law that is written down, and the system of interpretation of law, which is often more complicated. Now, law in general is divided up because as you have complex interactions with the law, you have complex understandings, there needs to be a certain amount of self-consistency, and that means that it's easier if you need different definitions of things to have them in different parts of law. In the United States, we use four broad categories, although there are a number of others, which are tort or civil law, that is lawsuits and outside of criminal action; criminal active law, or criminal law; administrative law, which is about how government and legal systems and formal bodies of administration should be done; and then separately contract law. And each of these four respond to different shared influences and distinct bodies of law as written. The bodies of law as written are what we mean by statutes and formal regulations. So, for instance, when Congress passes a law, when the state legislature passes a law, that becomes part of the statute, unless it's administrative law, in which case it is sort of a different thing. The negotiation of the influence of amassed precedents. Precedents are past decisions by judges, juries, and courts. There are also decisions that are brought down in other ways, but largely precedent is the trial record of past cases. And what's called the system of common law. So before the United States existed, we were part of England politically and legally. And we inherited the idea that one way for the law to work was all of the opinions of people, primarily people of authority and courts, come together to be a guide to the action of future courts. And so, strictly speaking, you can introduce, because we inherited this, ridiculous pieces of common law from 1300 into court in the United States. Last year, in response to a lawsuit against him, a lawyer on Long Island or Staten Island or someplace in the New York area actually asked the court to allow him to determine the outcome by trial by combat. Now, he was denied, but because the common law in 1450 or 1480, something like that, had allowed for trial by combat, where instead of having a jury trial or a judge decide, you fought, and whoever fought and won was the legal victor, not just the violence victor. It was entirely legitimate for him to go into court and say that the way that he wanted to resolve his divorce hearing or whatever it was by fighting her champion. It didn't go through. The judge threw it out because there are other precedents and elements of law that balance out for those older pieces of common law. All of the legal elements share some systems of warrant and some systems of logic. They don't necessarily share all of them. So, for instance, criminal law emphasizes what's called the social welfare element of law. That is, that we especially need to pay attention to criminal law, not because it protects individuals, but because it protects the whole body of society. And that means that, for instance, in many cases in criminal law, you don't have to show that a crime hurt individuals. It can be what we often personally would think of as a victimless crime. But the breaking of that law presents harm to the society as a whole. In contrast, it is very difficult to use torts law, civil law, to make a claim that the society as a whole is harmed. And in fact, even if you do that, you tend to have to do it in what's called a class action suit, where you are still finding representative individuals to claim personal harm. Otherwise, you can't move forward. By contrast, administrative law is, in the same way we have structural ethics, these are laws that are not necessarily immediately about maintaining social good or individual good. They are about maintaining the system of government. They are maintaining the system of law. And contract, in some ways, it is just a historical element, that contracts are so complicated and so established and so basic in law that they get to be their own thing. And each of them responds to things in different ways. You can think about that another time. You could read a lot more about the history and the formation of that process. But all of these elements actually do have influence even today. So part of the reason that we need to understand the complexity of law is that the history has had a particularly direct and important effect on how liability law works. That history of the common law, the history that the law begins in the pre-modern era, changes what we end up with today. So, for instance, we're talking about a system of law that at its basic earliest levels pre-existed the factory. right? It existed as a way of negotiating disputes that were almost all tiny, small-scale disputes in tiny towns set in agricultural communities. The common law did not really affect the nobles, the guy, knights in shining armor, the bishops, the kings. This was about normal people who had nothing. And one of the things that's important about understanding that is that the first era of liability law established that all liability, that is all legal responsibility, stemmed from a person to person, face to face interaction. And that the term for that kind of direct interpersonal relationship was a relationship in privity, right? So the direct relationship established by two people basically speaking to each other, shaking hands, signing a piece of paper or something. Um, I buy something from you directly. You and I have the relationship. And until really the 1890s, and not just the Industrial Revolution, but for almost 200 years of the rise of the Industrial Revolution and the formation of modern factory life, the globalization of industry, um, we maintain the idea that you are only responsible for those privity direct relationships. And what happens is, starting in the 1870s, before we change in law, people are increasingly unhappy with that. And one of the classic examples of this is prior to the change in law, if you hired somebody to do something directly and they did it badly, then you could sue that person. But starting in the 1870s, it became increasingly common for people to realize this limitation in law and act as intermediaries. So, for instance, if you wanted to have a house repair done, you hired a contractor, but the contractor then, instead of doing work himself, hires a carpenter. And it turns out that because his job that he's agreed with you was simply to hire the contractor, if the contractor never shows up and does the job, you cannot sue the contractor. And because the contractor did his job, he may or may not have any complaints about the carpenter not showing up. And so by establishing that you could chain together interactions in business, in product development, um, so that you never had to have personal responsibility for anything, because personal responsibility was only direct and one-to-one. That system broke down, and really until the 19 turn of the 20th century, right around the 1910s, there wasn't much of a way to do this. But the concept of liability law for products. Now, there were other kinds of contract law that applied to lots of other kinds of contracts. But as we move on, what we're really going to be talking about is product liability. And what it turns out is that if you make something and can sell it, or if there's a service or something and it's indirect, you sell it to stores, stores sell it to people, then it becomes increasingly a problem that nobody has a direct relationship in privity, and nobody is responsible if that product kills people. Try and imagine a world, for instance, in 1916, one of the best-selling drugs sold by pharmacists without a prescription was heroin. We decided at that period that somebody needed to be more responsible than simply, if the pharmacist lies and says this will be good and you die of an overdose. Well, that's bad, but it's really just the fault of the pharmacist, not the fault of the company that has told the pharmacist to give out heroin to small children as a cough medicine. I know that sounds so ridiculous, the idea that you would do that. Because, as we said, the idea of safety and risk changes as people's perceptions change and context changes over time. So, throughout the very beginning of the 20th century, in most of the English-speaking world, and this extends to the legal system that the British established in India, the legal system that is in all the Commonwealth countries in England, the United States, the modern Mexican legal system, all around the same time realized that increasingly economic and business connections had become more complicated than the traditional privity relationship. And so they began in one way or another to expand or extend the responsibility to deal with the expansion of manufacturing industry that involved resale. And as they respond to it, there are a couple of things that get established. For instance, that there is what's called a warranty. And a warranty is not like a piece of paper that comes with a product saying you can get your money back. They go back to a traditional idea in common law called warranty, which is that certain kinds of things have certain expectations of them. And so one of the classic examples of this is if you bought a candy bar, a piece of food, do you expect it to have broken glass in it, inedible things, or it could just be made of rock? If somebody sold a candy bar that was made of rock, that would break the expectation. And so the idea of warranty is that at one level or another, there are certain expectations that are legally enforceable in any kind of business interaction, theoretically in personal interactions also. So a warranty is not the same as a contract. A contract is, it is explicit, and it's one where the two parties, the two people agree to something together. Whereas a warranty is established by the kind of thing or the kind of relationship itself. And if you remember our discussion of warrant in general, this comes from the same linguistic element, right? So a contract is a contract because the two people form a contract, right? It could be a handshake, it could be a spoken deal, it could be written down, all kinds of contract, but both people have to be aware of it. But there are other things where you just go, no, this is warranted by the nature of it. It is justified by the nature of it, right? The nature of a family is that everybody in the family has some responsibility to each other. Now, you could eventually say that that's broken. Everybody in your family is terrible. You're going to stop paying attention. But that is actually not denying the warrant, the fundamental justification. That's saying that in this context, that warrant no longer applies. And so warranty is not the same as contract. And a warrant can be express or implied. So for instance, if I'm like, this candy bar tastes good, I have now expressly said that if somebody doesn't think it tastes good, we have a problem. Whereas if I sell candy bars that just say candy bar on them, it's implied by the name candy that it will taste sweet, it will taste good. If it tasted, for instance, terrible to people, there might be a conflict with the warrant of being a candy bar. An extended or indirect warrant can be that, for instance, if I sell a rock and it crumbles to dust the next day, that would be very surprising. Rocks last a long time. If I sell you cotton candy and it crumbles to dust the next day because it was humid out, that's not a problem, right? So the extended warrant can be things like a lasting object should last. That means that we may resell it, somebody else owns it, and it still should last. Or it may be an indirect thing. For instance, when we talked a moment ago about the idea that there is known and unknown risks, I used the example of asbestos wall panels. Asbestos is meant to prevent fires. During the time period nobody knew it was harmful, the warranty was, we promise this will not burn. It will help prevent fires. There was no, when it's an unknown risk, there was no warranty that is being broken. But at the point the risk is known, anything you're telling people they should build their houses out of, there is an implied, indirect system of warrant that says that thing should be fundamentally safe to live around. It shouldn't be radioactive. It shouldn't give off terrible gases. It shouldn't poison you. But as we see those things happen, it can be an express or an implied. That is, expressed or stated, or it could be an implied warrant. And as we move into complex relationships, if 20 people add parts to an engine, it may be that I only buy this engine from one guy, but all 20 people who put parts into it are indirectly part of the warrant. They are saying this object works in that context of the engine. And similarly, people notice that as more and more products are circulating, more and more sales are happening, there are times when, even though individuals are not going to be too pissed that something doesn't work, it could still present a problem for society. And actually, the classic example of this today is the question of the acceptability of using disposable water bottles and disposable plastic bags. Most people would say they are not harmed by a plastic bag. They don't want them to go away. If we look in aggregate, if you remember when we talked about the Matheson Gray Social Radicals article, we said many technologies have to be understood differently at the aggregate scale. And this also applies to the extension as we started thinking about what liability would be in the modern age. It's no longer one-on-one. So there are times when responsibility can be to society. And that these are the kinds of things that we started to try and figure out. And instead of having a relationship in privity, we start talking very explicitly about liability. And for the better part of 50 years, most people use what is now thought of as normal or traditional liability, just when you say liability. And that's different from in the 1940s, early 50s, in Texas, somebody sold a car, and it was determined that the idea that they should be responsible for the car as the car dealer was fair, but at the same time, the way that they were responsible had to be limited because they didn't know that the car was poorly designed. They were simply a dealer for the car manufacturer. Under traditional liability, there was still basically a limitation on that. So the harm was deemed in traditional liability to be mostly still direct. But liability, we'll get to exactly what's involved in it, was suddenly a way of saying, look, instead of being one-on-one, there is responsibility that we can apportion. We can describe this as their responsibility, and because it's their responsibility, they have a responsibility to assist in remedying that. And later we get to this point where we're starting to feel like that doesn't extend far enough. Other people feel it does extend too far. And so now if you can sue a car dealer for having sold a car that was poorly designed, even though they, as a dealer, didn't have enough, any real stake in how it was designed, there becomes a question of how to do limitation on that. And one of the ways to do that is to say, we'll have a stricter definition. And strict liability is different in one very specific way, right? It changes one of the requirements for having established liability. In traditional liability, you establish that a harm has been happened, right? So somebody somewhere is harmed. Then that person has the right to claim somebody is responsible for that harm. And the harm can be all kinds of things. It can be property damage, personal injury. It can be all sorts of harms, any kind of harm. Once they've been able to document and show that a real harm has happened, they then can say, look, this object, this thing that I bought, that was given to me, that I was assumed in warrant was safe, is responsible. And here is the causal link, right? In traditional liability, You didn't just say there is a causal link. This product caused the harm. You also had to demonstrate that there was a real chance that the person doing the design, making the product, would be able to to prevent or realize and not cause that harm. And in strict liability, we make it a little harder to make those first three claims. It's harder to do, here are the damages. It's harder to do the defect or the product is the cause, and here is the causal link. You make those stricter, but you no longer need to show that the person who designed it, who built it, whatever the person you're suing, has been negligent. And negligence is simply failing to meet the standard of risk and safety appropriate. Right? Determination of negligence means there's an unreasonable failure to meet expectation to prevent that harm. And so strict liability versus liability have to do with how difficult or how likely it is that somebody could have avoided producing the harm. So if we're going to go back, we'll just stick to that, figure out what liability is. We'll come back to strict liability in a minute. In liability, what we're talking about is a system of determining the responsibility after an action or an event has happened. And the system is determining whether blame and punishment, recompense or response can be determined. In fact, it doesn't actually say that nobody is at fault. It's only whether within the standards of law it can be determined. And in particular, it's trying to determine, like I said, whether the proportional responsibility allows for which of the people to be determined, right? Because it may be that the user did a little bit, but the designer is more at fault. And when we're talking about liability determination, we're talking about tort law or civil liability, and it's decided in lawsuits. And the less common criminal cases, which we'll talk about because one of the articles is talking about the extension of criminal law, we're really not going to get into the details of that. The opposite of ethical reflexivity or cost-benefit models that put much of the ethical work on good decision-making ahead of time is trying to decide what to do after something is done. And so one of the things to recognize is liability is specifically after the fact. It's not trying to head it off. The law focuses on influencing behavior so that it's not only about paying somebody back to try and fix the damage, it's also about trying to encourage and prevent future harms, right? So those complex, multiple directions and goals for the law in general all have to be operating here. We want to produce a good future. We want to prevent bad actions. We want to leave individual liberty when we can so that people can act how they want, but not so much that they hurt each other. All these things are still operating. And tort law generally defines the responsibilities based on accepted ethical rules or accepted legal rules. And what's really talked about as ethics in the law is more what we're talking about as morals or values in this class, right? Because they're not saying that the actual individual systems of ethics are what we're paying attention to. They're talking about generally held beliefs. And whether you should or shouldn't lie, whether you should be honest, those are the things to talk about. Now, in the last slide, I said one of the things that distinguishes regular liability from strict liability is the emphasis on the concept of negligence. And one of the things that is important about this is in traditional liability, negligence or not negligence is less the issue unless you can prove negligence. Unless you can prove that the person should have prevented the outcome, that it was an inappropriate outcome, it didn't really matter if the harm was there. So, for instance, One of the real challenges is um, the law often says we can't know what's in somebody's head. And so when we're talking about negligence, we're often talking about whether somebody did or didn't, could or couldn't know something. And that's a difficult thing. It's why strict liability makes sense, because we don't want to have to talk about whether somebody knows something. But at the same time, traditional liability did have a benefit that it meant that we were actually talking about the reason an action or a decision took place. Under strict liability, where we don't need to talk about negligence, it's often the case that we're literally removing much of the ethical deliberation from the event. We're not talking about why something is. We're not talking about in what way the decision or action was taken about. And so in some ways, one of the strange things is that while the strict liability will tend to produce more safe, better results, it actually erases some of the reflexivity and transparency. So now I know that you guys have read this and we've just gone over this before, but let's make sure that we have this. Liability is responsibility under law. Liability, particularly product liability, which is what we're focusing on in relation to engineering, that is that there is an object or an exchangeable good involved. That's what a product is primarily the subject of tort law. Torts are wrongdoings, harms performed by one party against another, and the injured party who may take civil action, that is a lawsuit, the other party in court. Not all not all lawsuits are about products or engineered goods or stuff like that. There are other kinds, but that's what we're going to focus on. And the way torts or lawsuits works, um, in some ways, comes back to multiple kinds of things. So, if you've intentionally caused harm, then that's one kind of thing. If it's obvious. So if I like walk over and punch you in the face, that's not going to be a traditional liability claim, because even though my action, my decision produces harm, it's not product liability, it's not liability, it's intentional harm. And one of the cool old-fashioned phrases is that it is willful and wanton, right? It is not appropriate. Um, Negligence torts, which still rely on that traditional idea of negligence, um, are different. And so one way to think about the distinction between liability and strict liability is that we're talking about negligence versus strict liability. Um, and one of the classic examples of this is um, whether or not the kind of risk, the kind of safety we're talking about is appropriate. And so a while ago in class, I mentioned an old-fashioned toy called a lawn dart, which is about a 3-pound spike with wings that you're supposed to throw up in the air, and it lands in a circle on the ground, and you try and score points. And it turns out anybody sensible realizes 3 things. One, this is an inherently dangerous thing. So then you get into this question of, are those dangers, are the potential outcome the right kind of dangers? Is it an appropriate form of thing? Or is it a real risk? Or do you consider it safe, even though somebody might get hurt? Um, and one of the classic examples of this question of negligence is um, traditionally they actually encouraged you to use this at barbecues, at social gatherings, where there are going to be lots of people. And they mentioned on the package that this was for kids who were like 14 and over. But they were already encouraging you to have it at events, to use this device as a game at events where small children might be present. And that meant that there were a lot more injuries than they kept claiming would be likely. Now, under traditional liability, where you had to say this is more dangerous than they led us to believe, where you had to say that they were unaware or unable to live up to the kind of standards for safety that they should have in the idea of negligence, It was actually for a long time assumed that because they said only people 14 and up should get should be using it, that they were actually being careful enough. And it was only later that it was switched into a jurisdiction under strict liability where they're like, look, you have this thing which is designed to stab, and you sell it, and people get stabbed with it. That that isn't negligence. That's exactly what's supposed to happen. But the design itself is producing this harm. And so, how you negotiate, and in fact, depending on where you are in the United States, you may or may not be subject to strict liability. There may not be the requirement that the person be negligent. And in different jurisdictions, different areas, different contexts, how you define which kinds of risks and safety or negligence do vary. And so, I said earlier that one of the early forms of predecessor to liability was this idea of breach of warranty, right? The failure of one person to sell something and it lives up to the inherent claim in the thing. Um, that if you're in breach of warranty, you don't have to have a contract. You don't have to have a written thing. You just have to be able to go and say, look, the jury understands that candy bars are supposed to be sweet. This candy bar is clearly made of rock. It doesn't have to promise not to be made of rock. And when the defendant comes out and says, my candy bar is called rock candy bar, anybody should know that. The negotiation there um, is about not whether it can cause harm, not whether it is negligent, but whether the selling of a candy bar inherently promises something. That's breach of warranty. It's not the same as contract because both people don't have to be involved, both parties, both systems, and it's a different system of law. And so there are a variety of different ways that breach of warranty and other related things happen. Expertise of selection. So, for instance, um, if you sell the world's worst product, and there are really good ones available, and it's something that doesn't matter. So, for instance, pencil sharpeners. If you go out and sell the world's worst pencil sharpener and it will never do a good job, um, that probably doesn't matter. But if you go out and sell a pencil sharpener specifically to places that are going to be doing SAT and standardized exam prep, and you sell them where it will have harmful effects, then you're actually producing a product that is not appropriate to the context of use that you're aiming at. And so the system of breach of warranty, which gets related things to be somewhat complicated, can often be about whether or not the object fulfills the kind of thing that it's supposed to be. And in like I said, in strict liability, we don't necessarily have to show negligence in the same way as under traditional liability. Um, but negligence is not the same as warranty. Negligence is the failure of a duty of care, right? It says that this is the sort of thing you should have cared about and responded to, not because you're special, but because anybody in that position, any engineer, any designer, anyone should have cared about this issue. So a defect producing harm, right, where we can demonstrate that the defect produces the harm, the causal link is clear, the specific negligence, the action or decision that could have avoided that harm or that causal link, right? The produced harm was not reasonable or acceptable. All right, so we've talked about what liability is, and we've talked about the general, and this is just to sum up, and then we'll move on to a few more ideas, right? So in liability, there are a variety of different possible causes or reasons for something to be liable: failure of warranty, failure of manufacturer design, failure of warning, instructions, or information, right? So for instance, in my silly example of the rock candy bar, if it had just said this is a joke product not to be eaten, then they would have avoided failure of warranty. And so in some cases, simply being transparent and honest in your information is the protection from liability. Um, the four elements of any case of liability, right, are the product design is innate, right? That is, somebody didn't add it, somebody didn't modify it, it isn't affected by the environment. Um, the design is the thing. The product design is faulty, flawed, or a defect, right? That there is something wrong with it. And in some cases, that could be a product design defect, where it's actually a result of bad design, or a manufacturer defect, or a defect of instructions and warning. The damage is demonstrable as harm or cost, right? So you have a product. It is the way it is because of the being the product, not because of me modifying it or you modifying it or the rain falling on it. The product design is faulty. The product design produces harm. And I can demonstrate what the causal link is, how the product made the harm. And in the next slide, we'll be talking specifically about what liability negligence tests are, so how we know. So whether you're talking about liability or strict liability, often the question of what and how things were designed, how things were happening, what kind of decision making is worth thinking about. And while in strict liability or general liability, um, the weight, the emphasis on negligence is different, it is still worth taking into account in either case. So the test to determine liability, these are distinct from overall negligence, right? In negligence, you have to prove the thought process or the series um, of ways that a decision was reached, a product was sold in general. And it can be fairly complicated, although in some cases, if you have like a letter, if you have, for instance, the memo that Lee Iacocca sent at Ford, where he says, fuck it, I don't care if people die, that's a clear sign of negligence, right? But most of the time, we're not going to talk about negligence in general. And we'll come back to the idea of criminal negligence, which can be negligent homicide, right? What we want to talk about when we talk about the concept of negligence and negligent homicide is the idea that the standard of care, the duty of care, the expectation of care, that somebody should be trying to do their job well. And if they don't try and do their job well, if they don't try and protect people's safety, then that is a legal problem. But for now, what we want to talk about is what demonstrates liability. So when we talk about there being a harm and a causal link to the product, in liability, one of the things is, could they expect and understand that, right? The test of reasonableness. If if you're like, I'm just going to do this and see what happens, that's recklessness, right? You're not taking the appropriate amount of time. If it's impossible to imagine that something is, for instance, we did not have chemical studies of asbestos for 50 years. Once we know chemically asbestos does cause harm, it's very reasonable to not use that product, to expect people to know that. But there are other tests besides reasonableness, right? One of those tests is the replaceability or the alternative availability, right? And this is based on the idea of consumer choice. So a classic example of this is early in the 20th century, there was a drug that was being sold. It was the only drug for that disease. And in about 50% of cases, it saved the person's life. In about 50% of the cases, it killed somebody. And for that kind of long-term parasitic infection, it really was the only disease, only drug that provided treatment. There was no possibility of an alternative. There was no replaceability. And so the question then isn't the same as if a drug could be replaced by a safe one. And one of the questions about replaceability is not that it's good that the drug can kill 50% of the people, But if people are making a choice and they have the choice of no treatment or of treatment, then the fact that the treatment has more risk is more acceptable. And often the concept of replaceability, the test of replaceability, is really about the negotiation of what is considered acceptable risk versus unacceptable risk. And the simple recent example of this is the Vioxx trials, right? Vioxx was a drug sold for people with heart conditions, with blood pressure problems, and they said this is better than aspirin. And the thing is that, in fact, for most people, it was better than aspirin, but it was only a tiny bit better than aspirin. It was um, slightly better than aspirin for most of the people, but because there was the option of aspirin, which had, except, in the population with these heart problems, didn't have to worry about taking aspirin. There was almost no side effects. Nobody dies of it. We're not talking about kids where there's Rye syndrome. The problem with aspirin um, was that it was an old technology and people wanted a newer and better one. And so Vioxx was then seen as an acceptable alternative. Eventually, it turned out that it wasn't just better. It was also killing some number of people who had it. And when they argued that the replaceability wasn't correct, that we couldn't just have been taking aspirin, that it was saving all those people, they argued that because some small number who took it instead of aspirin might have benefited from its being better, they were arguing that the replaceability did not take place. Right? It couldn't have been replaced safely with aspirin. And they lost in court, in fact, because it turned out that statistically, aspirin would have prevented all those same deaths. It was unlikely to have made a difference. And this also comes back to the next test, which is about predictability. And predictability or foreseeability is the question of, like the example of the asbestos anti-fire tiles, for 50 years, people used them. The science literally was not there. They could not have predicted that it would produce harm. And that's very different than, for instance, there was a nearly 50-year period where scientists working for the tobacco industry knew that it could cause harm, right? But attempted to prevent people from thinking of it as a harmful product. And that test of foreseeability, they could predict the harm, and therefore those kinds of harm were linked to the product in a way that liability should be held to them. And I mentioned earlier the idea of risk and utility. And this is, if we think about the Vioxx case, if 100,000 people were going to survive, even if it kills another 100 people, the utility of that drug is worth it, right? Saving 100,000 versus not saving 100,000 is worth potentially a risk to those other people. And in some ways, the risk utility arguments are the weakest because they rely on both a binary ethical choice, but also they they almost always rely on a balanced acceptance and evaluation of both the benefit of the risk and the risk utility, right? That it is good to use this risk, right, because we're going to get this result. And at the same time, we can accept that this risk is useful. Um, and risk utility is one of the ones that has particular problems when we get to courts because it is very difficult for most people to interpret statistical data accurately. And so it's a difficult one to talk about in terms of its utility as a test for liability. By contrast, there are a great many shields against liability. Um, the the most famous examples are laws. So, for instance, there's a law that says there is something dangerous about guns. You cannot sue gun manufacturers. No matter how much you want to, you can't do it. And in fact, that keeps being challenged, and they slowly chip away at the effect of that law in relation to the rest of the laws about liability. But for now, that statute, that law stands there and prevents those gun companies from being sued at the federal level. Uh, Standards are also a shield against liability. If you live up to and use an industry standard that is well established, it is very, very rare that anybody will credit you with a harm as a liability. Um, if you do work up to appropriate standards, it is usually a protection in court against being found guilty of breach of negligence or of liability. Um, the simplest is insurance, right? Have something that if you are found liable, it will pay. That's what insurance is for. And in fact, even something as simple as having fire insurance on your house is a prevention of liability, right? If you sit there and you're like, smoke, I could try and put out the fire, or I could go out of the house and save my life. Well, I have insurance so that if the house burns down, I will at least have something to fix the harm resulting. And malpractice insurance and other forms of insurance are a necessary requirement for most licensed professions, including engineering. Incorporation, that is the form corporations as a form of legal entity for businesses, exists entirely as a liability shield. The dominant form of corporation is an LLC, limited liability corporation. And in fact, corporations as a business entity um, begin to take off in parallel to and in response to the growing sense of need for stronger liability laws in the 1840s. So I said in the 1870s, people really start developing, pushing for larger, more serious uh, liability laws, and those liability laws really come into effect in the 20th century. And one of the things you see is that as companies get bigger, as industry gets bigger, as the modern world forms, businesses start to predict kinds of risks. And one of the ways to respond to those risks is the corporate form. And we've advanced and um, improved in the sense of protection corporations as a shield against liability ever since for over 100 years. I don't like that personally because I think corporations are a way for people to get away with doing bad jobs, to not feel the weight of their choices and decisions in terms of their effect. But I am not going to be able to change that. Similarly, as we talked about, one system of risk and one system of liability is about provision of information, proper labeling, producing the warranty and contract implicit in the good itself. Labels and information are a shield. The mitigation of risk in general is one way to do it. And the strongest shield against liability is good design, right? We don't want people hurt. We want to do a good job. And that means that taking seriously the responsibility of engineering is the best shield against liability and against lawsuits. So statutory liability, which is general or strict, strict is in 40 states, doesn't base on the knowledge, intent, action of designer, right? It is simply, with the exception of the debate about negligence and about how it fits in some court cases, statutory liability, by and large, is simply a harm happened, the causal link is clear, and the object is as designed. And when we look at that trio, the place where you can act is the design itself. In the Vartar and Wagner article, which you guys will get a lot more detail about these issues from, they focus on one particular aspect of this issue of liability and the arguments back and forth, and that is that one of the things that often scares young engineers is the idea that they are making a permanent technology, a contribution to the world that has lasting impact. And that means that theoretically, at least, they may have a permanent responsibility for the effects of that technology. And that is, from an ethical standpoint, an absolutely important instinct for you to have. You, as we've talked about in looking at Winner, in Mathis and Gray, designers and engineers do have a fundamental responsibility and a fundamentally long-term and significant impact on the life of people in the world. And that is a significant and weighty thing. Now, the Wagner article talks about this, and they say one of the issues may be that this doesn't have to be a permanent responsibility. And if it is a permanent responsibility, how do we handle that? Well, the duration of responsibility for liability can be handled in a couple different ways. And traditionally, most kinds of law, including tort law, has, if there are limits on the time scale, on how long you can be held responsible, those are called statutes of limitations. In the 1940s and 50s, some states started arguing for what are called statutes of repose for product liability only. This is not a general concept. Most crimes, you'll see things on cop shows. You can't arrest me. I broke that law 20 years ago. It's long past the statute of limitations. So this is literally a law that says this is how long we can expect you to do it, to go to jail for this crime. A statute of repose is a little different, and we'll get to the difference in a minute. But a statute of limitations, we literally say the clock starts at the moment the law is broken, the harm is done, as opposed to a statute of repose where the clock begins the moment the completion of the product, the design, the enactment. And this is important because sometimes you'll design something and the design will sit there for 20 years and then somebody decides to make it, and are you still the responsible party 20 years later? Similarly, if you make something and standards and perceptions change in the world over the next 20 years, and then it's released by a warehouse or a company decides to sell it, that thing may be understood and perceived differently. The questions of those tests for liability, knowability and reasonableness, those can change over time. And so the perception that having a permanent or a long statute of limitations, which is based on when the harm happens, they argue is prejudicial against designers of technologies and stable objects. And this is most especially true in the case of architecture, where, for instance, the term of life for a house can be 100 years. What if they maintain it poorly? What if the ground shakes? How is it that we have to do that? And my argument would be, hey, if you're really worried about this, go back to me saying good design is the way to do it. If you are worried that in 100 years your grandkids will be paying for your mistakes, make a house that'll last 100 years without a problem, right? But the law does need a duration of responsibility established, so it does so. Now, statutes of limitations are always based on the idea that when a harm or crime happens, it's that moment that starts the clock. A statute of repose suggests that with a manufactured product, even if it's used for 20 years successfully, we shouldn't then start the clock when it's used and the object produces the harm. Because you're effectively saying you ignore that 20-year period or that 10-year period or a year that it was working just fine. So a statute of repose says we can look at the different classes of types of manufactured good and have a period during which they are expected to perform well, and a period after which where the warranty, right, that inherent warranty, not a written warranty, where the warranty has ceased to guarantee. And so in the article, they talk about the history of this and the variation that it produced. And one of the central concerns is as time has gone by, and one of the reasons for statutes of limitations, evidence becomes harder to spot, witnesses become less reliable, even something as stable as design records and memoranda from the company are harder to find if they exist at all. And so as time passes, one of the reasons that these rules that establish time scale for legal responsibility are the way they are is because the idea is that you could no longer meet the legal standard for evidence to explain it. All right, so I've mentioned negligence, and I actually gave the definition a while ago, which is when you act without concern for how your actions will produce bad effects. And the basis of negligence is what's called the duty or the standard of care. It's the expectation that you will care about who and how your actions have results, right? This is a legal standard that is based on the same kind of ideas that are established in consequentialist ethics, that one should care about the positive and negative results of their actions. And in particular, there's a difference in the duty of care, which is established by a specific role or relationship. So, for instance, an engineer has a duty for care in their professional capacity as an engineer. And in fact, even an unlicensed engineer still has a duty of care as an engineer. The expectation of care is more general, right? Everybody should care to some degree. And then once those expectations and duties to care are recognized and established in law, they produce a standard of care, how much you have to care, so that the established demand or need of a person to be concerned about the effect of their actions, particularly to work to prevent their action from causing harm, right? So it is about the risks that can be avoided. And there are two kinds of negligence in American law in some ways. There's gross negligence. You just don't care, right? You did not show the appropriate level of care. You, in fact, demonstrate a disregard for possible outcomes, right? It is, when I talked earlier about negligence, one thing I said is one of the reasons we go back and forth between strict and traditional liability is this issue of how can we know what goes on in a person's head? And so gross negligence can be hard to prove, right? Because all somebody needs to say is, I tried to think of that. I did care, but I failed, right? The realization of indifference may be difficult to establish. And in contrast to that is culpable negligence. Culpable negligence just says, instead of being gross negligence, you are culpable, that is responsible. And this is a statement that responsibility is applied as if you were negligent. Culpable negligence can be achieved through the specific act that caused death or through the action set the stage for the resulting death. And in fact, it can mean harm rather than death, although by general acknowledgement in U.S. law, culpable negligence is mostly about severe cases. If it was regular, normal harm, and you could not prove gross negligence, right, that the person demonstrated they didn't care, it would be hard to prove negligence. And in some ways, this is very similar to the distinction between strict and regular liability. In one case, you are showing that there was an action and there was a harm and there was a causative link. In the other case, you have to have a question about the reason or the relationship to the person producing the thing. So when we talk about negligence, generally what we're talking about is that the failure to produce a good result is because you didn't try. And the term for that is recklessness. So in the Willits article, they talk about this and say recklessness, aware of and consciously disregarding a substantial and unjustifiable risk that the result will occur or that the circumstance exists. Right? That's the definition they're using. And they go on to talk about it and say the risk must be of such nature and degree that the disregard, therefore, of a constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. And we're back to that test of reasonableness. So it's very difficult to say somebody was reckless if their action was of the kind, if their thinking was of the kind that most people would do. In some circumstances, recklessness can be charged or legally responsible. In other cases, it can't be. So recklessness is often the legal standard where we go from the possibility of a legal trial in a torts case in a lawsuit to the question of if recklessness has occurred, especially in a professional capacity, somebody may have been so badly breaking the expectations that we're looking at that legal question of if their actions are a threat or damaging to all of society or an individual, right? So a person who's recklessly endangering other people, it's not just going to be a risk for one other person. It's a risk that begins to be for everybody. And so in the Willits article, they're talking about the fact that in order to prevent recklessness, we really need to reinforce that this is, or one of the possibilities to reinforce the demand that people not act recklessly, we could use criminal consequences. So if recklessness is to be dealt with in that serious a way, there are a lot of questions about it. And in fact, most places in the United States, it's difficult for prosecution to bring a case against somebody for criminal negligence. And in many places, criminal negligence is a different crime than negligent homicide, right? So in criminal negligence, we're just saying your recklessness, your negligence causes harm. In negligent homicide, we're saying that acting significantly outside acceptable roles, not just for a profession, but can be, but for any person, right? We just don't care about human life. And that in not caring about human life, you effectively killed somebody. Whether you intended it, your lack of care has produced the killing. And so Willett is interested in this particular extreme case where we're going to talk about many engineering disasters can be seen potentially as criminal negligence. And he's arguing it may be better for society to consider extending that criminal negligence so that we recognize how very similar criminal negligence and negligent homicide are. So usually in class, we talk about a number of specific and significant cases. Um, the, the most famous of these we usually go through, and I'll try and do a very brief version of it, is um, the, the McDonald's lawsuit about the drive-through coffee burn. And I actually will recommend there's a good summary of the case on the TV/web series available on Netflix called Adam Ruins Everything. I think the episode is called Adam Ruins Justice. But we talk about it slightly differently because what we want to do is talk about it as an example of why the myth of frivolous lawsuits don't actually exist. Um, the the groups that have promoted that there are lots of frivolous lawsuits have misrepresented that. And similarly, we also want to talk about the fact that there is a myth that good engineers, good corporations act to the best of their ability in very specific and serious ways. And so we use those two cases to talk about these two myths, the myth of frivolous lawsuits, and then using the Volkswagen emissions scandal as a representative example of the myth of corporate responsibility. And today, I'll do a very quick version of these. Um, if if my voice holds out, I may talk a little about the third case that we usually talk about in the lecture. So the thing is that the myth of frivolous lawsuits is just that. It's a myth. It's not true. In order to have a lawsuit heard in court, you have to present all of the evidence you're going to do, and you have to present the elements of liability. So you have to show a harm, you have to show that there was a problem with the product, and you have to show a causative link. And in order to even have a day, even to have the person know that the lawsuit is filed, the court has to have perceived evidence of this. And so if you want to think about it this way, almost 90% of the people who go and request a lawsuit to be heard in court are turned away. That's about 1 in 10 get to the sake of having a one-day hearing in court. Of the 10% of lawsuits that make it into court for the first day, 90% of them, when the defendant presents arguments, are kicked out of court without a second day. Of the 10% that move to a full trial as opposed to an evidentiary hearing, that means that 1 in 100 trials manages to make it that far. Less than 10% of those trials continue to the end without a dismissal or a plea. It's not a plea deal, an agreement between plaintiff and defendant. I'm suddenly blanking on the word. So that means that in the end, less than 1 in 100 make it into court in reality. Less than 1 in 100 really end up going into full strength trials. And by the time you whittle down, you narrow down through all of these steps. One of the things is the idea that all these lawsuits are frivolous is in fact ridiculous, because almost 80% that manage to go through the full trial process find against the person being sued in product liability. And the reality of that should be very clear, that in fact, if you can make it to trial, if you can make it through the trial process, it is almost always because there really was a problem. And before you say, well, that's just because the courts managed to keep frivolous lawsuits out, it's in some ways just not true. We have a history in the United States of making fun of or dismissing the claims of people who sue based on a needed recompense. But very few lawsuits are frivolous in the large term of things, the large scale. And one of the most famous cases is what's the case is actually called Liebeck versus McDonald's Restaurant. It happened quite a long time ago in the early 80s, but a woman was burned by McDonald's coffee, and this for a long time became it's like a joke case where somebody's like, oh, didn't you know coffee is hot? But it's worth recognizing that it wouldn't have become something we can joke about if it hadn't made it into court. And it wouldn't have been in court if there wasn't a serious claim here. So when you hear about this sort of thing, when you hear about the threat or reality of a lawsuit, recognize that often that is because there is a genuine problem. And in the coffee case, there are a lot of steps to the case, but the question comes down to those definitions of what constitutes risk and safety, and that what is reasonable. So a woman bought a cup of coffee, and while she was pulling out of the McDonald's parking lot, the coffee spilled, and it gave her third-degree burns, which are very serious, on her legs and groin. And she goes to the hospital, and then she finds out that in order to have skin grafts and treatment for her burns, it's going to cost her hundreds of thousands of dollars. And she says, I've spilled coffee before. It shouldn't burn like this. I'm going to sue McDonald's. And McDonald's initially says, don't be ridiculous. You can't sue. She points out that there is a direct causative relationship between this cup of coffee. And her lawyer asks for the documents from McDonald's Corporation to describe why and how the coffee was so hot. And in the process of what's called discovery, right, when the documents from a company or from a lawsuit are made clear to both sides, McDonald's revealed that they had determined that people using their company wanted the coffee to be hot when they got where they're going. If they used the regular kind of coffee makers that everybody else used, what would reasonably be expected, the coffee would be below boiling. And the average, according to their research, was a 20-minute drive to work or to home from McDonald's. In order to guarantee that the coffee was still piping hot near boiling, they actually had the coffee makers turned to a pressurized system that meant that the coffee on dispensing was above the boiling point of coffee. Um, and that meant that when you put it into your cup, into your car, it was superheated, which sounds ridiculous, but this was a design decision that McDonald's made. And it may or may not be enough to say that they did not perform reasonable care, just that. But you got to remember that you guys are younger. You live in a world where every car has coffee cup holders. In 1985 or 6, whenever the case was being determined, less than 1% of cars were manufactured with cup holders. Only certain kinds of luxury cars had them. So as a reasonable precaution, McDonald's should have been able to pay attention. If you're given a cup and you're driving a car, where do you put the cup? I'm pausing because I want you to actually think about that. Because any of you who've had this happen where you've been given a cup and you're supposed to hold it and there's no cup holder free, you put it between your legs. And it turned out that not only was the coffee in the cup hot enough, but the cup was not insulated enough. So McDonald's had already settled multiple lawsuits where people had been burned through the cup and through clothing by heat emitted by the coffee. Not only that, but this was one of a pattern of 30 or more coffee burns that had led to second and 30-degree burns since they used the new coffee manufacturing, the new coffee making machines. The nature of the trial was not about one person. And so, in fact, we often hear people make fun of this case, but the case came down to two things. She was the first person who was willing to move past settlement to a full trial. And therefore, because it was the first time to go to a full trial, it was the first time where the court was asked not only to present the liability in terms of repaying the person for harm, but to act on the need for public safety. And so the woman's original claim was just for medical bills. And the court, in the end, found that she was correct. The, the harm was produced by a negligent or defective product by McDonald's. And not only did they give her the medical bills, but they said after a pattern of negligence and multiple times that people have been burned, we believe that we need to reinforce that McDonald's changed this policy. And so they did punitive damages in the case to try and get McDonald's to change, which is where the $1 million come from. And it's worth remembering that, first of all, I think it was very generous of the woman to only do medical bills, given that she was out of work salary and all sorts of problems. She had been burned in her genitals at third-degree burns, which is something horrific to even contemplate. And that she did not ask for the punitive damages. That was a determination of what was best for the public good by the court system. And that's pretty representative of how the complexities of the legal system of courts get translated not into a question of how the courts try to limit the determination of design effects by private companies, but when it gets translated into news, it becomes a joke about women not knowing how hot coffee is. And we got to remember that if you go back to thinking about the systems of complex regulation that Lawrence Lessig talked about, that one of the systems in action is the technology itself. Another are the social norms and conceptions, right, that define reasonableness and demands, that also influence McDonald's desire to have overheated coffee. But one of the elements that he talked about is that laws are so important because they are the only one of those things that has direct ability to enforce or modify market and business forces. Right? McDonald's will always have a greater emphasis on being able to sell 1 million cups of coffee that people are happy with, even if it badly burns 30, 40 people. Right? They will never learn their lesson unless there is a system of law, such as these tort laws, that do so. Um, Now, the myth of corporate responsibility is that there is a financial demand placed on corporations to do their job well, but that the financial demand is then enough to assure that there is corporate responsibility. And for those of you who don't know, the Volkswagen emission scandal was that basically we passed laws saying the public safety um, for both climate change reasons and quality of air for people's lungs reasons. We needed better quality emission standards from cars. Rather than following those emission standards, Volkswagen had computers that cheated the tests, and they did it for a long time, and they got away with it until they got caught. And the argument here that is often the case is that um, we can rely on corporate responsibility most of the time, in part because there are large penalties when a corporation does this, right? When a corporation like Volkswagen cheats, they are then slapped down, and other corporations know the penalties are significant and will be responsible. And this is one of my favorite, like there were about 40 different national class action suits, government suits, as well as the actual legal fines for breaking the law that Volkswagen faced. And Volkswagen had this great statement. The spokesman said, Volkswagen remains confident in our case that we are not liable to the claimants as alleged, and claimants did not suffer any loss. We will continue to defend our position robustly. Nothing in this decision today changed this. This was in response to the fourth large class action lawsuit, which showed that their cheating had been linked to higher emissions. And their argument is that climate change and indirect harms are not a direct result. They actually continue, even to this day, to argue that while they did break a rule, the rule did not harm anybody. Their breaking it did not harm anybody. And I always find that to be ironic that even after being found guilty in court, they continue to argue they're not guilty. But of particular note is that much like the discussion we had about the Pinto case, where the lawsuits presented no barrier because the cost of the lawsuits was lower than making an alternative design decision, Volkswagen has made $1 billion on their sales. They don't care if they have to pay $100 million. And in fact, there was a lot of discussion about the Volkswagen emission scandal causing stock harm to Volkswagen, but over the years since, it has rebounded. And what we can generally find is that historically, very little has been affected in terms of corporate policymaking by lawsuits like this. And so the myth of corporate responsibility being reinforced by these things is amazing. Now, at the more contemporary end is lots of groups are saying that they are being harmed by the action of companies like VW, like oil companies, because climate change is exacerbating lots of problems. And one of the amazing things is here, these parallel these other issues, and we get ongoing conflicts over the cause of harm, right? If systems are too complicated, it is very difficult to demonstrate, according to the legal standard, what is called the causal link, right? We have emissions and we have climate change, but how do you prove which emissions from cars, which oil used, which plastic? results in climate change. And so there are a lot of climate change lawsuits out there which are then not ending up changing business policies. But in all these cases, what we're negotiating is the legal definitions of liability, and we'll see if in the long run the changes in how and who people are suing do have different or greater impacts on corporate responsibility than they have in the past.